A very warm welcome to today's webinar in our SeedFast series on the process and key milestones of a financing round. This is already our 8th session in our series designed to help startup founders to become investment ready. So far, we walked you through the key steps of a financing round, explored the different types of capital increases, and discussed both the term sheet and the legal due diligence. In our last 3 sessions, we focused on the investment agreement, the shareholders agreement, and the closing. Today, we focus on the last steps of the closing process, and we will discuss which resolutions do you need to implement the capital increase. Dominic from Konsento will guide us through the key considerations when preparing for the final steps of the closing process of your financing round. But before we begin, just a few quick administrative notes. The slides and recordings of all webinars in this series are published on the LinkedIn pages of Konsento and Lex Futura and are also made available on the SeedFast website. And if you follow Konsento and Lex Futura on LinkedIn, you'll also receive occasional updates and tips to support you in your journey as a startup founder. And with that, let's get started. Dominic, the floor is yours.
Well, thank you for the introduction, Alain, and also from my side, a warm welcome, in particular with this summer weather. Well, as Alain mentioned, the closing of a financing round consists primarily of corporate resolutions. Basically, a capital increase is a sequence of corporate resolutions, ahead of which or between of which specific documents are being created. Anyway, the type of corporate resolutions and also the number of corporate resolutions depend largely on the type of capital increase you perform. In one of our first sessions of this series, we presented the different forms of capital increase that are possible according to the existing Swiss law. So we have the ordinary capital increase, then we have the contingent capital increase. This is mainly for participation programs, employee participation programs, and convertible loans. And then we also have the capital band. And on this slide, you see which type of resolutions are necessary for each type of capital increase. So in case of the ordinary capital increase and the contingent capital increase, you need a resolution by the general meeting. So the shareholders approve the capital increase because they get diluted and need to be protected against the consequences of dilution, and therefore also need to agree with the capital increase. We come to that again in more detail on the last slide. And then the ordinary capital increase and the contingent capital increase also need a confirmation resolution by the board of directors, where the board states that the capital increase has been performed as decided and approved by the general meeting. And then we have the capital band, which is the most flexible form of capital increase, which gives the most autonomy to the board of directors. Again, here I would like to make reference to one of our earlier sessions that you also can find in the internet. And if you're interested to see the details and the differences between those forms of capital increases, you can also watch that session that we had. But coming back to the different type of resolutions, in case of the capital band, you also have the general meeting resolution as well as the confirmation resolution by the board of directors. But in between, the board of directors needs also to decide on the implementation of the capital increase. So they will decide that at a given point in time, they will perform the capital increase. And that's very important and must not be forgotten, because if you end up having the confirmation resolution by the board of directors and the notary wants to see the minutes of the implementation resolution by the board of directors, and you didn't do that in the past, you need to redo it, which will cost you time on the final stretch of your capital increase. On this slide here, we will see the different features of those individual resolutions, because depending on the type of resolution and the type of capital increase, the requirements are different. So you need to prepare different motions with different contents towards either your shareholders or the rest of your board and the notary. Let's begin with the features of the resolution by the general meeting. In some types of capital increase, an amendment of the Articles of Association is required. This is the case in the contingent capital as well as the capital ban. So therefore, be prepared, take the time to either prepare the revised Articles of Association or see a professional specialist who can support you with that. Then some type of capital increases require a deadline or define a deadline in which the capital increase must be finalized. In case of an ordinary capital increase, this deadline is 6 months. Again, here, I would like to make reference to that specific session on the different type of capital increases, but the ordinary capital increase is the one where you should already be prepared and have your investors on the sideline so you can finalize in due time. In case of the capital band, there's a timeline of 5 years. Again, this gives the board of directors the most flexibility. And then if you decide for a contingent capital increase, you have no timeline and can increase the capital whenever you want in the future. So depending on whether you already have investors or you need a lot of time and want to have a flexibility in terms of time where you want to close your financing round, you can distinguish between those different type of capital increases and choose the one that applies the best for you and for your case, your situation. And also bear in mind that not all the capital increases require the same majority by law of the shareholders. So in case of an ordinary capital increase, it's a simple majority because it's being performed immediately. Whereas in case of the contingent capital increase and the capital band, a qualified majority is required because those types of capital increase give the most autonomy to the board of directors, and because the shareholders delegate their powers in deciding on a capital increase, the law requires a 2/3 majority. And then for all the types of capital increases, there are very detailed and precise specifications required, which means that you need to be aware ahead of the meeting on the number of shares that you want to create, the nominal amount you want to increase, depending on the capital increase type, the issue price of the shares, etc., etc. So you shouldn't approach your shareholders with a motion that is not detailed and precise enough. And then also for all the resolutions to increase the capital, which are taken by the General Assembly, a notarization is required. Therefore, also please think ahead and organize a notary public that will witness your resolution at the AGM and then prepares a public deed on that. Then we have the implementation resolution by the board of directors. This is only required in case of the capital band. It also needs to be very precise and detailed with regards to the specifications of the capital increase. Again, number of new shares, increase amount in nominal value, issue price, etc., etc. And then very important also, this must be recorded in minutes, duly signed by the members of the board of directors. It's not required to have a notary in that meeting, but at a later stage, the notary would like to see the minutes of that resolution. And then we have the confirmation resolution. That's basically the last step you have to take to finalize your capital increase. Again, this will be in the presence of a notary public. This notary can either join the meeting physically in person or also, given today's legal circumstances, online, depending on the canton. I'm just taking a look at Alain. He was a little bit shaking his head. I think there are distinctions between the different cantons. Maybe we can elaborate a little bit on that in the Q&A session afterwards, if we have the time for this, and if I don't talk too much. And then again here, we need very precise and detailed information on the performance of the capital increase. So actually with this meeting, the board of directors states that the capital increase was performed according to the law and also in line with the authorization of the general meeting by the shareholders. And also in all the cases of all capital increases, the articles of associations need to be revised also and reflect the new capital. And then the last step, the very, very last step, is the filing with the commercial register. So all the documents that need to be prepared need to be filed with the commercial register. And also for this meeting, for the confirmation resolution, a series of documents need to be prepared, beginning with the report by the board of directors. Then we have the Lex Futura declaration. We have the registration form with the commercial register, and then also the public deed. And depending on the type of capital increase, additional documents. So why are these resolutions required? And why is it so important to follow all the steps necessary, to provide all the documents necessary, and also to be so precise in the details of the information provided for each of those resolutions? First of all, the shareholders are protected against dilution. So every shareholder has a given stake in the company, and by law, he is protected against dilution. And if he gets diluted, or she, they need to approve the capital increase ahead of that. And in order to be able to assess the amount of dilution, they need all the details required by law in order to get an opinion on that. Then transparency and traceability is very important. Transparency and traceability requires, first of all, documentation, which is publicly available and which is also detailed enough. So this will help shareholders, authorities, and other third parties to assess on whether the requirements by the law and also the approval by the AGM has been followed by the board of directors when conducting that capital increase. Then another reason for the documentation, but also that very precise and detailed information, is the legal certainty. So the law states specific procedures for a capital increase, and this guarantees the equal treatment of all companies throughout Switzerland, and in particular also all investors within the same company. So it's very important that authorities like the commercial registers, for example, treat all the companies equally, but also all the shareholders. Then also there are creditors of each company, and they need to have the comfort that the capital, which is being stated in that documentation of the capital increase, really exists and was really invested into the company. And this is basically the main function of the notary public, as well as auditors in case an auditor is needed, and the commercial register, which all verify that the amounts documented that were invested into the company were really invested into the company. Yeah, and then we have the commercial register entry, which is basically the prerequisite for the availability of the capital. So if you have the invested amount on a capital contribution account, this will be blocked by the bank until the registration of the commercial register is updated and reflects the new capital. And so all those measures ensure that nobody can cheat about the real capital invested into a company.
Thank you, Dominic. Let's go back to the online meetings. I thought that was quite interesting. So first, I think in most cantons, the notaries are able and also have the necessary legal basis to do online notarization. I think a few cantons, you can't do it, even though the federal corporate law provides for it. The cantonal notarization laws sometimes do not. In my cantons, you can, but there are still some hurdles which are different in various cantons. For example, in some cantons, the chairperson and the minute taker need to sign the minutes by hand. In some other cantons, that's not necessary. Obviously, it's much easier if it's not necessary, because then you don't have to send around physical paper, even though you do an online notarization. But I think we're moving in a very good direction that in a few years' time, you can actually conduct the notarization online without any physical barriers. But you're right, it's not always easy to understand the differences in the various cantons. And luckily, there is still the option to do most of the resolutions via a power of attorney, except the board resolution, which, as we all know, you cannot be represented by someone as a board member.
Yeah, exactly. As you say, there's a lot of work in progress and a shifting of paradigm when it comes to filing with the commercial register and also public notarization in Switzerland. And the whole topic of digitization is not as easy, because it's not just copy-paste of the existing workflows, but it requires also new workflows, new tools, etc., etc. And this is not very easily to implement by the authorities as well, to have the same security and comfort of legal compliance, and therefore takes time, and not all cantons move at the same pace. So I fully agree with what you're saying, and I observe the same in our day-to-day business.
And maybe coming back to your day-to-day business, what is your experience? What's the most likely mistakes people make in the closing process? Or what are key tips you can give the people out there when it comes to a closing of a financing round? The formal aspects.
Yeah, the key tips I would say is plan ahead. Be aware of what the requirements are and what is required by you. And there are always legal professionals that help you. More and more, there are also digital solutions that guide and manage you, like the ones that we offer through SeedFast. So you can plan ahead and take your time to plan ahead. Because if you have a meeting with the notary and you realize a couple of minutes ago that, for example, the motion that you propose to your shareholders is not specific and detailed enough, you cannot perform the meeting. And then you need to re-invite everybody to that meeting. You need to postpone it, in the worst case, by 3 weeks. And this is important and valuable time that you lose in between those resolutions, and the steps towards also getting access to the money which is blocked on a capital contribution account. So I would say that's the primary mistake. Maybe the secondary mistake is also something we dealt with in the last session. That's the accuracy of the data provided. So what we see a lot is that people work in different Excel sheets, maybe different people within the same company or the board of directors work in those sheets, and then they lack a single source of truth. And you know, what I've seen in some cases was that we received Excel files where, for example, the invested amount was in some cases in US dollars, in others in Swiss francs, and they were not converted correctly. Or data on the investors were not collected correctly, so they had, for example, nicknames of companies or abbreviations of company names which were not in line with the name according to the commercial register. Then the notary comes and verifies if those investors exist. And that's a very easy one in case of a company that is registered in the commercial register of Switzerland, and they can't find that company. So the investor formally doesn't exist. So these are two examples of inaccurate data. So yeah, be precise, work diligently, work carefully, and prepare the data accordingly, or use again a digital platform for such cases, because it streamlines the data, it has specific data formatting within the platform, and therefore supports you in avoiding those mistakes.
I fully agree. Maybe one additional point, which I basically every time encounter, is the fact that people think between the signing and the closing, it's just a few days. But they then forget that you also need like an auditor certificate, for example. You need all the investors to pay into a blocked account. Then you need the commercial registry to perform the actions within a reasonable amount of time. Sometimes it takes 2 weeks because they have a lot to do at certain periods of time. So it can take a very long time, and not even the notary is responsible for this. It's actually having all the documents ready as quickly as possible, and then you're basically dependent on the quickness of the commercial registry, and that's always an expectation management task also, because you can't speed up the process there.
Yeah, I agree with you. That's interesting, because if you do all the work of a closing of a financing round manually, I think you can do this in 2 days work time if you work focused on that. But in between, they lose so much time that the whole time period of the closing of a capital increase takes several weeks to even months, because some people are very uncoordinated, don't know what the next step in the closing process is, etc., and therefore lose a lot of time. And that's, again, very, very valuable time. And with the necessary support and necessary preparation, you can speed up that whole process to finally a couple of days for doing everything, getting all the resolutions, preparing all the documents, and getting access to the money on the account.
Definitely. Thank you very much. That was very insightful. By now, everyone on this session should have a solid understanding of the closing process. And our goal is now in the next session, that's the final session of our webinar, to show you the advantages of the offering of SeedFast, where we help pre-seed and seed startups in their financing round by using the digital tool of Konsento and the legal expertise of Lex Futura. The next session takes place on the 9th of July, again at 11 a.m. And I'm looking forward to seeing a lot of you there again. Dominic, have a good day and talk to you soon.
Thank you. You too. Bye-bye.